Hi, my name is Cameron Stevenson, and I'm a medical malpractice attorney at the Levin Papantonio law firm here in Pensacola. I would like to take a few minutes to discuss with you some very important and historical developments in the realm of medical malpractice in Florida. In this country and in the state of Florida, we as citizens have traditionally upheld a long-standing belief that our jury system is simply the best mechanism to produce just outcomes when civil disputes arise. We believe that a jury of our peers, after listening to all of the facts and all of the evidence presented by not one but both sides, is in the best position to sit in judgment on another in determining whether or not one party is liable to the other for damages and what the amount of the damages should be. These principles are actually rooted in the express language of our Florida Constitution. What we are not, and what we traditionally have never been, are proponents of a strictly construed, one-size-fits-all system of determining liability and damages that completely diminishes the duty of the jury and the relevance of the individual sets of facts and circumstances that are present in every single legal case, especially those involving medical malpractice. Systems such as these that take these issues away from the jury are in direct violation of our Florida State Constitution. Nevertheless, in 2003, our very own Florida legislature successfully stripped our juries of their duty and responsibility to determine non-economic damages in medical malpractice cases, for example, mental pain and suffering. The Florida legislature has basically told our juries what they can and cannot award when it comes to non-economic damages such as mental pain and suffering, without even giving the slightest consideration for the individual set of facts and circumstances presented in each case. According to Section 766.118 of the Florida statutes, no longer can a jury listen to the facts and evidence presented by both sides and determine for themselves how much mental pain and suffering damages they should award to an injured patient in this state. Rather, the jury is now bound by an arbitrary, one-size-fits-all damage cap that decides for them the amount of money they can award. Simply put, the Florida legislature has looked Florida's injured patients straight in the eye and said flat out to them, "We are not willing to give you or your family members the same pain and suffering damages for your injuries that we are in fact willing to give to those injured or killed in situations outside of the medical malpractice context. For example, being hit and killed by a careless driver." After hearing this, you should be asking yourself, how is that fair? How is that just? How does it even make sense? To limit someone's recovery when they suffer the exact same injuries as another just because of the manner in which those injuries were sustained. It does not make sense, and there's no way getting around that fact. You should also be asking yourself, how did this happen in the first place? How was this legislation even passed? The answer is that our state senators and our state representatives are routinely influenced by big-time lobbyists for the healthcare industry. All the while, the voice of the injured patients in Florida are never heard. Why? Because injured patients in this state do not have the money or the forum upon which to voice their opinions, upon which to be heard. Our state senators and our state representatives are only getting one side of the story, and the injured medical patients of this state are suffering the consequences. This absolute travesty has plagued injured patients and their families for years, slowly but surely having their constitutional rights swept right out from under them. Thankfully, the Florida Supreme Court now has the opportunity to right this wrong that has existed for over a decade. In the recent 11th Circuit Federal Court of Appeals decision of the estate of Michelle McCall versus the United States, the 11th Circuit certified 4 critical questions to the Florida Supreme Court seeking clarification on the constitutionality of the Florida medical malpractice damage cap statute. This historical development will finally give the Florida Supreme Court the opportunity to weigh in on this monumental issue and strike down this clearly unconstitutional taking of rights of Florida's injured patients. Only time will tell if the appropriate decision will be reached by our High Court, so that juries can rightfully determine, once again, the amount of mental pain and suffering that should be awarded to injured patients in this state. Please stay tuned to levinlaw.com for a synopsis of the published opinion soon to be issued by the Florida Supreme Court.